Mike Gallagher. I'm a lawyer from Houston, Texas. I've heard most of the testimony here today, and I don't want to.
Put your mic over, Mike. Yeah.
I don't want to replow the same ground that you've been over, but there are some important policy issues associated with this legislation that I think are more far-reaching, obviously, than Senator Taylor. You've indicated a lot of the things that are contained in this legislation, and I understand how drafting difficulties can occur. We're what we call unintended consequences. And there appear to be several in this particular piece of legislation. First thing I want to say is if the issue you're trying to address is the elimination of solicitation of cases, ambulance chasing storms, then and the illegal obtaining of business, the Texas Trial Lawyers Association, I as an individual, and the lawyers with whom I associate are all of one mind with regard to those issues. We stand ready to work with you in any shape, form, or fashion that we can to make a positive contribution toward the resolution of that problem. Because as you've pointed out, there are good lawyers, there are bad lawyers, there are good adjusters, there are bad adjusters. The good lawyers of this state want to see it go away as badly as anything else that exists in our practice, because it discredits all of us who try to do what we do in an honorable fashion. Now, with regard to this particular piece of legislation, one of the problems, and you've heard this time and again today, and I don't want to reiterate it and rehash it, but for instance, you define a person on page 1, subsection 2 of section 1, you define who a person is, and it has been pointed out. You eliminate from that definition adjusters, engineers, and a litany of people who are involved in the claim resolution process. Then, in section 2A, which creates the liability or the acts that for which compensation, the acts that are in violation of this statute, the very first section, 2A1, talks about misrepresentation of a material fact to a policyholder is an act for which immunity is provided. Yet under section 701.051, if a person misrepresents a material fact to their insurer in a circumstance in which they're preparing a sworn statement, then that gives rise to, I think it's a Class C misdemeanor under the section of the business code that you're amending in here. And just when you juxtapose those two positions together, you give immunity to a public adjuster for misrepresenting a material fact versus you punish a consumer, not you. I don't mean to be saying you. The bill has this effect. You subject a consumer to being prosecuted for a Class C misdemeanor when they do engage in exactly the same conduct, though maybe unintentionally, that for which immunity is provided because of the definition of who a person is. And from a lawyer standpoint, and I'll close. I've got 57 seconds left, and I'll try to finish up. From a lawyer standpoint, when the underlying tortfeasor, the person that commits the wrong, has immunity, therefore is not liable, then my concern is that the corporation, the insurance carrier that writes the policy, that's being adjusted by the public adjuster to whom immunity is given, will then not have any vicarious liability, derivative liability, respondeat superior, or any of the traditional legal theory, Senator, that we think about, because there has to be a legal basis for the imposition of liability. Now, if statutorily you can create strict liability, if you will, on the part of a carrier for conduct of a public adjuster, that might be something that can be accomplished, but it's certainly something that needs to be addressed and considered. And the abolition of state court jurisdiction in cases of this type by giving immunity to the person that creates state court jurisdiction, in effect deprives our citizens, and we've got somebody mentioned 200 years of federal jurisprudence. Well, we got about 160-something years of Texas jurisprudence, in which we proudly provide a judicial system of which I'm quite proud. And our citizens access it, and this bill would destroy that access and force them into a federal system when our Texas courts are here. They've done a good job since they were constituted under the Constitutional Convention, and I think we ought to be able to access them. Thank you very much.
Thank you. Senator Taylor?
Yeah, thank you, Mr. Gallagher. And you and I have had the opportunity to work before in the past.
Yes.
And I appreciate it. You've always been very reasonable. On
Thank
page
you.
3, it talks about an insurer on line 16 is solely responsible for any violation of subsection A by an individual employed by the insurer as an adjuster or a third-party individual or entity engaged by the insurer to provide adjusting, estimating, consulting, engineering, or other services related to the insurer's adjustment of claim. Getting back to what my intent was, we're not trying to get rid of that liability. We're trying to make sure that the insurer, so we can leave, once again, the reason I brought this portion up was because the independent adjusters were getting named on all these suits, that they really weren't the one that's going to be the ultimate payer on the deal. So we're trying to be specific that it's going to the insurer who hired that independent adjuster. So does that help in any way with any of that?
I applaud your effort, but my concern is that in the context of this legislation, in the context of our common law and construction of statutory law in this state, there has to be a legal foundation upon which liability can be created, upon which liability is predicated. And here, when the underlying actor whose conduct has created the circumstance of liability is given immunity, then you can't be vicariously liable, you can't be derivatively liable, you can't be liable under the doctrine of respondeat superior, being responsible for the acts of a third party, because that underlying person has immunity. That's my concern from a purely lawyer standpoint with this particular piece of legislation. Of course, I do have problems with the granting of immunity to adjusters, particularly in the context of what I've heard here today. What we're really trying to deal with is bad actor lawyers, and I'll be the first to admit they're out there, and I'll be the first to admit that our organization stands ready to work with you in any way possible to try to address this situation as we have forever. But while that gives me some ground for concern, this definitely means that every one of these cases is going to be removed to federal court, because as one of the speakers, I think the first speaker today, indicated to you, lawyers that represent consumers think their clients get a fairer shake in state court than they do in federal court. Conversely, the carrier feels that they get a better deal in federal court than they do in state court. And the carrier is going to remove this case every time they can in a diversity situation. Those of us who practice on a regular basis I don't think in the 45 years that Mr. Longley's been practicing, he's ever told me about a circumstance in which he sued a foreign corporation and the case wasn't immediately removed to federal court. They just remove them as a matter of practice.
Thank you. I appreciate
Thanks,
the
Senator Taylor.
comment.
Senator Ellis and Senator Watson.
So, Mr. Gallagher, you come up with some ideas on what can be done to get rid of the bad actors out there who are practicing law. And I'm just curious to know, will one of the items on that list be to give those bad lawyers immunity? You think that'd be one way to get rid of them?
I'd like to give them something, but it wouldn't be immunity.
I do want to ask that.
And I'd like to do it with impunity.
Ms. Gall, was there anything, you went through your major points, was there anything else, just briefly, I want to make sure that you...
Other than just saying that the bill seems to be so heavily balanced in the providing of immunity and benefits to the carriers, and I know this wasn't your intent, and at the same time limiting severely the rights of the consumer, that I just think that it needs to be readdressed and it needs to be reconsidered, and you indicated today that that's something that you're interested in doing, and we thank you for that. And we'd like to be a part of that process.
Senator Ellis.
Thank you. Just one quick question for the other witness. Is it Ms. Carmen?
Yes, sir.
In your case, did you have to get a lawyer in order to get your coverage?
I did hire an attorney, yes, sir.
Do you think there's any way you'd have gotten there with your insurance carrier if you had gotten a lawyer?
If I had not,
if you had not gotten a lawyer?
no, sir, we tried. My husband and I tried, and it wasn't going to happen.
So you made the comment earlier, if this law had been in effect then, that you wouldn't be here. Is it fair to say that if you hadn't gotten a lawyer at some point, that's a possibility you wouldn't be here as well?
If I hadn't have gotten an attorney, I don't know that I would have continued with treatment.
Well, thank you.
Because, you know, you're trying to fight cancer. You can't fight an insurance company at the same time.
Well, I know it's tough, but thank you for coming. It's not easy to come and share your story, but that helps a lot of other people.
Thanks, Senator Ellis. Thank you. Senator Watson?
Yeah, just real quickly, I just wanted to put a fine point. Earlier today, when you first laid out the bill, that was one of what Mr. Gallagher was just saying, is part of what I brought up in the morning, in our morning session, that what worries me is the portion of the bill that you read to him. An insurer is solely responsible for any violation of subsection A. It's on page 3, line 16.
I got it.
An insurer is solely responsible for any violation. On page 1, you have written, not you, the bill is written in such a way where an adjuster or a third-party individual or entity engaged by an insurer to provide adjusting, estimating, consulting, engineering, or other services related to the insurer's adjustment of a claim cannot commit that violation. And therefore, what happens as a legal matter is there can't be the vicarious liability, there can't be the respondeat superior or derivative liability. And that's what we've been talking about today, and I know you want to.
May I just say one thing on that point, and then I promise I'll shut up.
Promise?
And y'all will have immunity. What you're saying, the reason what you're saying is true is because there can't be a violation of subsection 2A by anything other than a person. And since a public adjuster is not a person, then a public adjuster can't be in violation of 2A. And, you know, some thoughts crystallize after you've been looking at something forever, and that just did for me when you asked that question. And that's why, Senator Taylor, the attempt in 2C to make the insurer solely liable falls short, because under the immunity section in your definition of person, the public adjuster is excluded from that. And whoever drafted the bill, I note, did change the noun from person to individual. And
I noticed that too.
that sort of raises questions in my mind again.
Thank you. Members, any other questions of this panel? If not, thank you both for being here. We appreciate
Thank you.
you.